Hey everyone, welcome back. In today's video, we're in Judge Washington's courtroom where an eviction case is underway. It's about a woman who believes she can cancel her lease agreement and live rent-free forever. Let's jump into it. If you don't think the court has any authority, why show up in the first place? If someone tried to serve me an eviction notice based
Court will call the matter of the Ranches of Rosebrook versus Anise Battle, case number 25C 1245.
Good afternoon, Your Honor. David Fantera on behalf of the plaintiff.
Ms. Battle, could you please state your name?
My name is Denise Battle.
Thank you so much, Ms. Battle. All right, today's the day and time scheduled for a hearing in this matter. This is an action to terminate the tenancy based on non-payment of rent.
Yes, Your Honor. I object to these proceedings moving forward because, like I said, I do have a verified petition in emergency motion for injunction in the U.S. District Court, which is the case number 25-CV-11233.
Thank you, Ms. Battle.
And like I said, this court has not put on the record of their jurisdiction. There's nothing on the record, and it stands. Every notice that I've sent is unrebutted, which stands at law. And jurisdiction is a threshold issue that we shouldn't even made it this far without discussing proper jurisdiction.
All right. Anything else, Ms. Battle?
As of right now, no.
Okay, thank you.
But I object to these proceedings in jurisdiction, subject matter,
All right.
and personal.
All right, your objection is noted for the record. Ms. Battle, I've already ruled on jurisdiction when we were here last time. We will be proceeding today. The court does have jurisdiction. Mr. Fantera, and Ms. Battle, do either of
The
you
court
have?
cannot, I object. The court
Ma'am?
cannot declare its own jurisdiction
If
to
you
a sponsor.
keep interrupting me, ma'am, you're going to get held in contempt of court, and the court does have contempt powers, so throw you in jail.
I interrupted you. Okay, that's all.
Your Honor, I want to point out also that Judge Vandenberg actually addressed this issue last Wednesday and said that the 14B District Court and Your Honor does have jurisdiction over this matter. So not that it needed to
May
do
I
that.
add, Your Honor? Yeah. She also said that she was not aware of the things going on, so she just went on for anything based on what he just said. She said any law nor facts, just as you don't, of why you have jurisdiction.
on a made-up theory like this, I'd just tell them to talk to my lawyer at Mossberg, Smith, and Wesson. I know it's inconvenient to deal with a court hearing, but if rent had been paid, we wouldn't even be here today. You can't demand fair treatment from the court while also claiming it has no power over you.
All right, thank you. Again, Ms. Battle, this court has jurisdiction and we will be proceeding today. Mr. Fantera, well, actually, the both of you have an opportunity at this time to do any opening argument that you want to make. So, Mr. Fantera, I will start with you. Do you have an opening statement?
I'll waive my opening statement, Your Honor, and just get right to the evidence.
All right. With respect to service, can you please put on the proofs regarding the service in case there is an appeal?
Say that again, Your Honor.
Can you please put on proofs regarding service in the event that there is an appeal?
Service of this lawsuit?
Yes, on Ms. Battle.
I believe that she was served by a court officer with Jimmy Moore's office, Your Honor. I think there's a proof of service in the file. I don't know whether it was attached or whether it was personally served. But the court has that proof of service.
With respect to proof of service, the file indicates that Ms. Battle was served with two different ways pursuant to MCR 4.201D, which is she was served, actually three different ways. She was served with an original mailing from the court, and then a second mailing went out from the court. Second mailing was requested by the plaintiff and was sent by this court. On March 28th, there was a mailing. And then there was service by Edward Cope, who was the court officer That service was effectuated through securing an attachment to the main entrance of the tenant's dwelling unit. And that was done on April 4th, 2025. And after attempts had been made on April 2nd at 12:40, and then April 3rd at 9:53, they finally did an attachment on April 4th at 4:30 p.m. In addition to that, Ms. Battle showed up to the court on April 9th, 2025 before the magistrate, therefore acknowledging that she had received service in this matter and that service had been perfected. Right. With respect to jurisdiction, we addressed that at the last court hearing. This is on Russell Court, which is within the jurisdiction of Ypsilanti Township. All right.
Yeah.
What requests were you making, Mr. Fantier?
I know the last two times that Ms. Battle has appeared, she appeared with a video, and this time she's just on her phone. Can we require her to be here by video today also?
I would have had to give
Well,
her.
the thing is like I tried to tell you all last time that the time was bad. This is when I pick up my kids.
You're standing in the middle of a hearing, demanding justice, while at the same time refusing to recognize the court's authority. What really needs to happen is for you to leave the property. I understand you have your own legal...
All
So
right,
we can do it like earlier or something of that nature. Yeah, that's fine.
then I'm okay just proceeding as long as the court is comfortable that we can swear her in when she goes to testify.
Thank you. I am comfortable. I can tell you that if I was going to require that she be here via video, I would need to give her notice of that prior to today's date. So I'm comfortable proceeding as we are.
Okay.
All right. And Ms. Battle, other than jurisdiction which has been noted and reserved, do you have any other argument you want to make today with respect to this matter in terms of an opening argument?
Of course. So, like I said, the contract has been rescinded on April 1st, and it was due to unconscionable pieces in the contract, including pieces that's wrong with the formation, as well as material breaches that's inside the contract. That contract has not been
You said
material breaches.
Oh, okay, go ahead.
Breaches, yes, within the contract as well. That was sent out and received. Well, it actually wasn't received on April 1st because at the end of the day, the unconscionable pieces, their addresses are wrong and the owners are wrong on the contract. So it got sent back. But once I realized it was sent and received on April 8th, 2015, and still remains unrebutted. They have yet to unrebut it in any case that we came and talked about the contract. And by law, according to Wall versus Zendaya, the Michigan law recognizes rescissions at common law for breach, fraud, and unconscionability. Meaning, if I give notice and it's unrebutted, that stands at law. Also, I've talked on personal matter jurisdiction, in which why I came in under special appearance the first two hearings, because at the end of the day, I'm not a legal person. I'm not in a legal capacity under Michigan law. I do not qualify as that person, which that person is a corporation, a trust, individual, in some type of legal entity of that nature, an association. I do not qualify as one of those people to be here and subjected to this without consent. Hence why, things were sent administratively and defaults were given administratively, because things are happening right here where I'm being deprived of due process, and I should be awarded due process by law.
Ideas, but it's the judge who will decide if the lease you signed is valid or not. The lawyer is now calling the property manager as a witness, and she's ready with evidence to support the eviction. It's too late to try to bring in new witnesses now. This is already the middle of the trial.
As the attorney stated last time we were here, he was saying that basically burden of proof only applies in criminal cases, which is false because the burden of proof applies in all civil cases where jurisdiction or contract validity challenged, and that's Taylor versus Bullock in 1992 in Michigan. You still have the burden of proof. The court cannot establish their own jurisdiction being based on a contract is rescinded. You have to have a valid contract to come into court about. So that's where your jurisdiction of the subject matter is at hand because the contract is rescinded, not unilaterally, like he's tried to claim before. It is rescinded, meaning I gave you notice and it's unrebutted, just as if somebody came into this courtroom for an eviction, or if they did not come for the eviction, you'll give them a default because what happens at law, your silence stands.
All right, thank you, Ms. Battle. Mr. Fantera, you may proceed with your case.
Plaintiff would like to call Dawn Charles as a witness.
All right, Ms. Charles, please raise your right hand to be sworn. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing.
I do.
Thank you. You may lower your hand. You may proceed.
Ms. Charles, please state your name for the record.
Dawn Charles.
And what is your position with the Ranches of Rosebrook?
I'm the property manager.
Are you familiar with the tenancy of Anise Battle?
I am.
Are you familiar with the lease agreement that she signed?
I am.
Your Honor, I submitted to the court a lease agreement dated November 12, 2024. I'd be moving for that to be admitted as Plaintiff's Exhibit 1.
Did you also provide a copy to the defendant?
I did not, because I do not have her email address. But she should, Your Honor, I should say for the record, she should have a copy of the lease because it is, because she signed it.
Any objection?
I never received a hard copy of the lease, and I've asked for a hard copy of the lease. Never received it, and as I read the lease, that was also a breach of my lease, as I was supposed to receive it and sign it in person, as they made me sign it over online. So again, the information that he's saying about the lease is correct. I'm not here to argue about the lease as far as what the original contract was. I'm arguing about the validity of what it is now, which is invalid and void because it's been rescinded.
Plus, if you don't think the court has any authority, why would you think it can call new witnesses? The term constructive possession doesn't mean what you think it does.
Right, given that she's not arguing about the validity of the lease itself, I will allow the exhibit.
No, I've said I did argue about the validity of the lease as far as it being valid, because it's not. But I'm not arguing that I entered into a lease on or around December 6th. That's not what I'm arguing. I'm arguing the validity of the lease. So let's correct that.
You're arguing, you're not arguing that you entered into the, what are you arguing?
Like I said, I do not object to actually entering into a lease. What I thought was, yes, a proper lease or on or around December 6th. I do not deny that, but I do deny the validity of the lease because the lease has been rescinded and it's unconscionable. Yes.
Thank you. You're arguing that the lease is rescinded is not being admitted. The lease is admitted. That objection is overruled.
On what facts of law?
The fact that I just ruled that, ma'am.
That's not a fact or a law. So let the record show that he has no
the record shows everything. The record shows everything, ma'am. You don't need to say that. And please stop.
I know it will when I pull the transcript, because like I said, this case is also.
All right, Mr. Fantera, you may proceed.
Okay, I want the record to show that I find it unfair that you can cut me off and use my mic whenever you feel like it, but I can't talk and have a fair hearing.
You're going to be held in contempt of court and you're going to do jail time.
It's used in criminal law and doesn't apply here. What you probably meant was constructive eviction, which refers to when a tenant leaves a rental because the property has become unlivable.
Mr. Fantera, please proceed.
Ms. Charles, can you, under the terms of the lease, what is Ms. Battle's monthly rent?
$10.75.
$1,075?
Correct.
Does she also have to pay utilities?
Water and sewer.
So for what months has she not paid her rent?
March, April, and now May.
So she owes $1,075 for each of those 3 months.
Correct.
Does she owe the water and sewer for those 3 months also?
Yes.
How much does she owe for those months?
Her water and sewer.
Yes.
So March is 36.24.
April,
35.45.
May,
35.73.
okay. That totals 107.42, correct?
Correct.
Are there late fees under her lease?
There are
What is the late fee?
$50.
On what day?
The 6th.
And so she's being charged a late fee for March and April, correct?
Correct.
So the total amount that she owes is $3,225 in rent, $107.42 in utilities, which is also rent, $100 in late fees, and then she would owe the court costs of this in this matter, correct?
Correct.
Have you reviewed the work orders that have been submitted by Ms. Battle since she has been a tenant?
Yes, I have.
Are you comfortable that they were all completed in a timely fashion?
Yes.
No further questions, Your Honor.
Thank you. Ms. Battle, do you have questions for Ms. Charles?
Yes, I do. So the first working order, are you able to disclose, or do you know firsthand what that was?
Your first work order was your shower water wasn't hot. You had some screws in your hinges that weren't secure. And when the water was turned on in the tub, it comes out of the shower as well.
Okay. So how do you define complete? How is that work order complete?
Well, that was the work order you put in. The notes for repair are that the diverter for your hot water was repaired. Our construction company fixed the tub faucet that had came off, and we installed new screws in hinges on the door.
Right. So do you have anything that the actual construction company came, because nobody came? Because even if you go on to the next 3 orders, that's also listed as an issue because it was never addressed.
Well, the next work order after that was actually December 26th, and it says the door that was repaired, the screws were still not right, so we put new screws in it, so that wasn't a work order about the tub. The one after that was January 28th, and that was about hearing animals in the attic, and we installed new soffit and made sure nothing was in there. There was also one on January 27th. We adjusted your shower head and plunged your toilet and tightened a basket on your sink. There was one on February 14th that your tub was not draining and water was coming out of the faucet. We unclogged the tub and the shower head was working properly. And the last one was March 17th that your furnace was cutting on and off. And we took your furnace apart and checked all the fuses and put it back together, and it was up and operating properly.
Okay, so let's go into that more, because we might even have to subpoena the maintenance man, because this is going to become an issue.
Like if the heat stopped working. But for that to apply, you need to show the property was uninhabitable. Let the landlord know and give them time to fix it and actually move out. It seems you may have done some of that, but since you stayed in the property, you gave up the right to claim constructive eviction. If you're really eager to show...
So when you say that you came into my bathroom and screwed the shower head, what would be your purpose of doing that? Because what was my request? My request was that it was still, the water was still coming out of both faucets at the same time, which have not been correct because you have not gotten a contractor out here. A contractor has not came out to my house about that. And let's go on to the heat, right?
Miss Battle.
I'm sorry.
You can't testify now. You can ask her questions. You will get a chance.
Okay, I'm gonna ask her a
was
question.
in
You're right.
the apartment between December 15th and 16th because the
Wait a
work
second.
order was
Wait,
closed.
no, everybody stop.
Wait.
There's no question
You
on
said I
that.
had to form it as a question. I apologize.
Okay, go ahead, Miss Battle.
Okay. So you're saying that a contractor came out, you said December 16th?
Correct.
And what contractor was that? The contractor that did the job?
Correct.
Okay. And when that contractor came out, what did they say that they did?
Repaired the tub faucet that had came off and repaired the tub diverter.
They
for
repaired
the
the
hot water.
what that came off?
The faucet for the tub
One more time. Uh-huh.
and the diverter for the water.
Right. Okay. So let that address it. That the faucet pushing out and the diverter, that doesn't address the issue of the plumbing, which really, when I had somebody come out, they said the wall has to be taken down because what happened is they messed up behind it. So again, let's rephrase. Let's go on to the new one. Let's go on to the furnace. So when they came out for the furnace and they came out to fix it the first time, what were their results from that?
I only have one work order for your furnace. They took it apart, checked the fuse, put it back together, and it was up and running. They cleaned it and put it back together.
Okay.
The furnace is new.
So no, it was two work orders. One was done in the middle of the night. In the morning before they came into work.
Your Honor,
So I just wanted to be clear. So you don't have that work order for the morning. I'm asking the question.
1 second, there's an objection.
Your Honor,
Oh, you said it was an objection?
Can you listen to it, Miss Battle?
I can hear him now. You say he had an objection?
Your Honor, I want to object. We're getting into the weeds here. I mean, you don't have a right to withhold rent or rescind a lease because of something small such as a tub faucet. And so, we're getting into whether somebody actually came out and fixed it or when it got fixed. And it just seems to me that this is irrelevant to the proceeding that's going on today.
Well, it's object because it's not irrelevant to the proceeding because it's part of the reason on why I caught out the breach. Because at the end of the day, I kept trying to get somebody to come out to fix these things that are not fixed. Heat is a major thing. It's been cold. I still have a heater in my house because they haven't came back and got it and fixed it like they said they were going to. You get what I'm saying? It's still unconscionable things in the lease regardless. So everything about what I am arguing here is valid because I do have the right to rescind the contract based on breaches of the contract, just like you can come here on a quote unquote breach of the contract. It's the same thing. Why do I not get the same right and to hear what's going on so she can hear what's going on?
Your Honor, we will be more than happy to, the purpose of rescission, as the court knows, is to put the parties back in the same position they were before the contract got entered into. We will be more than happy to rescind this contract and basically have Miss Battle pay what she owes through the date of move out and terminate it so she doesn't have any more rent owing after move out. The problem is what she said to Judge Vandenberg last week, and I believe what she believes, is that when something gets rescinded, she is allowed to live there until she finds a new place. And that is not the law. We are more than happy to rescind this, to do away with this contract, let her pay her balance through the date of move out and terminate this contract so that she can move on and we can move on. But what we can't let her do is to live there forever without paying rent.
Well, let it show that by law, by contract law, if the breach is on your end, if you want to comply to it, like I said, because I did rescind it, and the breach was on your end, and it's rebutted on your end, and by law under the landlord and tenant, it is called constructive possession. When you are in breach of a contract, and I'm not at fault, I am allowed under equity and law to stay in a place. It's called constructive.
Go up in court again, doing something illegal would get you there. But that's obviously not the best idea. That's it for today's video. Judge Washington has scheduled the next hearing for a few weeks from now, and she'll need to appear on video. We'll see how that plays out.
Ms. Battle, that's not the law, ma'am. That is not the law. Absolutely not at all. And ma'am.
Okay, so then if that's the case, if he wants to call out the breach of contract, then he's making it an uneven deal. Okay? So if he wants to say that he wants to accept the breach, then he has to accept the damages that come behind it. Because there's damages if I have to relocate on something that's not based on me. That's unfair. And that is that's unfair in bad faith.
Your Honor, I'm not trying to be unfair. All I'm trying to say
the breach is not on me. The breach isn't on me. So if the breach is on me, I will understand what you're saying completely. The breach is not on me, so I should not be held liable for y'all breach.
Yeah, but you're the one that wants to, Your Honor, but she is the one that wants to rescind. So it seems to me that she can't have.
I want to rescind based on the unconscionable contract. And what does my rescission also say? If it says it, if that's the case, if you all want me to leave and you don't want me to have the constructive possession, then you ought to be paying for my relocation because it was your injury to me.
Can I say something without being interrupted, please?
I want you both to stop talking for a minute, please.
Go ahead. I'm sorry.
So, first of all, if you want to talk about whether a contract can be rescinded, that is not typically what happens in a landlord-tenant. That's in a standard contract situation. However, if there is, in fact, a situation where capital is for you to get some of your monies back. That's not something where you get to just rescind the contract. That's why all of this is the wrong procedure. However, Mr.
I'm sorry.
Please. Mr. Fantera.
You were saying something about getting your money. I need you to go back a little bit. It's breaking up really, really bad.
So you're entitled,
I can't hear you clearly.
if in fact the court were to find that, for instance, the property was not habitable, like there were enough repairs that were done so that the property was habitable. We're not going to be able to make this out with the children in the back. My recorder is saying she can't make it out.
I'm trying to make it out too, and it's just like breaking up a little bit. That's why I tried to tell y'all that this was not like a good time for me at all. Remember, you had got his time, and when I went to go say my time, you cut my mic off, and I was literally trying to tell you that I cannot. It's 3 o'clock. Is just not a good time. I'm getting my kids out of school. I don't have help when it comes to getting my kids out of school. We can continue to try, or we can just try to go for a morning time. I can do morning time.
I have on the mornings. You don't have to figure this out. And if you don't figure it out, then the repercussions will be against you. You're gonna have to figure it out.
Well, hold on. I am trying to figure it out. I wouldn't be here if I wasn't trying to figure it out, or if I wasn't trying to,
I grant you that. I agree with that. But I have criminal dockets every morning. We don't have morning docket.
You said what about a warning? Hey, stop. Hey. You said what about a warning?
I said we have criminal dockets in the morning, ma'am. Is what I said.
Yeah.
If you enjoyed the video, please hit the like button. If not, feel free to hit dislike. Leave a comment below and make sure to subscribe and turn on notifications so you don't miss any of my content. I'm Team Skeptic, and I'll see you next time.